Welcome to the What Makes a Great Trial Judge podcast, part of the Lawyer Minds ecosystem. We've paired up with Lisa Blue, a practicing psychologist of 46 years and trial attorney of 44 years, to discuss some of the ways trial judges, especially those dealing with trauma-intensive cases, can improve their techniques and social practices, making the litigation experience more meaningful for jurors and litigants alike. So, how do you tell the difference between a great trial judge and one who needs to work on their social intelligence skills? Let's find out. We'll be interviewing some of the greatest trial judges around who offer tips for improvement and share their secrets. And with that, here's your host, Lisa Blue.
Good morning, the Honorable Judge Earl Brit. Hi, as you know, I'm Lisa Blue. And we're here to talk about your experience and what you think makes a great trial judge. So, Judge Britt, if you wouldn't mind, would you tell us a little bit about your background, how long you were on the bench for, which bench, and the kind of cases, just general background?
Thank you, Lisa. It's good to see you and participate in this video conference. When I first started practice as a lawyer, I had no idea that I would be a trial judge. I practiced law as a country lawyer for some 21 years. Started out with an older brother and two other fellows, and I did everything that could be done, from the preparation of timber deeds to the trial of first-degree murder cases. During that period of time, I think I observed many of the faults in the system that caused me to later adopt some of the policies that I adopted when I became a judge. I was appointed in 1980 by Jimmy Carter and confirmed on April 23rd, I believe it was, by the United States Senate. I was sworn in on May 30th, 1980, and I stopped accepting assignments on May 30th, 2022, after 42 years. As you are well aware, one of the last cases I participated in was what's been referred to as the hog cases, which involved a lot of citizens of eastern North Carolina who brought suit against the hog industry to try to rectify some misdeeds that they felt had caused them to lose their quality of life. The jury in those cases resoundingly agreed with the plaintiffs, and the Fourth Circuit Court of Appeals affirmed my decisions in all respects except for the admissions of some evidence on the issue of punitive damages. I was fortunate when I first came on the bench to have a mentor, a senior judge who had gained prominence in trying cases, particularly the infamous McDonald case that happened at Fort Bragg, North Carolina. He was a trial judge in that, and it went all the way to the Supreme Court and the Court of Appeals several times, and he was always affirmed. That fellow still in, Dr. Jeffrey McDonald, he's still in prison. Frank never would read about the case because he said knew that it was going to stay with him the rest of his life, and it did many times over. But in any event, I was able to have him as a resource and walk down the hall where his office was to find out perplexing problems that I had. Well, one of those involved a case that I got from him by reassignment, because he was, it involved a former client of his. And when I went down to, the lawyers came to me and told me that they had worked out a plea deal, that actually it was the fellow was charged with a misdemeanor. It was a high-profile case in North Carolina at the time. Even though it was a misdemeanor, the parties had reached an agreement which called for a specified sentence of probation. And I walked down the hall to talk to Frank about it. And I told him exactly what was involved, as much as I knew. And he told me at that time and gave me one of the best pieces of advice I've ever received. He said, don't ever, ever agree what the sentence is going to be until you've heard all the evidence in the case. And I went back and told the lawyers that. They did not enter the plea. The jury convicted the fellow. I sentenced him to prison, and he served it. It served his time. But Frank Dupree was a source of a lot of advice over the years, which I was able to put to use. I remember very vividly one of the best pieces of advice I received from him was make a decision promptly. Receive all the information about the case that you can before you make your decision. But once you have made your decision, don't allow anyone to talk to you about it at all. If they are dissatisfied with it, he used to say they could take the I-95 rule, which in our district meant appeal to the Court of Appeals in Richmond, Virginia, which is right just up I-95 from Raleigh. That proved to be a very valuable piece of advice for me over the years. And it resulted in my being able to not only enjoy my life more, but Frank said at the time, he said, the next cases in line deserve your undivided attention, and says you can't give them that if you're continuing to worry about the case that you've already decided. Not only did that help me in that respect, but it also helped me in my personal life. I've never had a moment's trouble going to sleep at night worrying about a case. I guess I'm blessed in that respect, but I attribute much of that to Frank's advice.
Have you ever, in any of your career, gone back to a case and said to the lawyers, I made a mistake, I want to change my mind? Has that ever happened to you?
No.
And I love what you said about the way you used your mentor. When someone becomes a judge or they've been a judge for a short period of time, what are the best ways that you can think of to use another judge or another person as a mentor?
Well, the best way that I know of is to establish a close relationship with that judge. In fact, he and Frank and I were the only two judges in our courthouse. It was very easy for me to walk down the hall and talk to him about things, though I did not do it often. I reserved talking to him about matters of utmost importance that I couldn't resolve in other fashions. And I think that he was able to provide me with the guidance and foresight that I needed then, particularly then. I was a general practitioner, and I tried cases all over the docket and all over the country. I mean, all over the section of North Carolina where I lived. I tried some small cases like breaking and enterings and minor damage lawsuits on the civil side to major felonies such as first-degree murder and civil cases that reached the North Carolina Supreme Court and the United States Court of Appeals for the Fourth Circuit. I had a very general practice. I started out representing plaintiffs in automobile accident cases. And fortunately, I was able to exact some good verdicts for plaintiffs. And I later on was put on retainer by some of the insurance companies. Not an exclusive retainer. I always reserved the right to take a case if it came in first to me, if the plaintiff in the case wanted me to represent him or her. Because by that time I had already learned about the case and I would have been disqualified from representing the defense in any event. But that was all right with the companies. You've also asked that I list what I think it takes to be a good trial judge. And I think the most important aspect of being a trial judge, other than having a mentor, which I've just already mentioned, is having patience. My feeling is that the lawyers have a right to be heard, the people have a right to be heard, and that the least that I can do as a trial judge is to hear them out. It gets taxing at some time doing that, but I've always felt that a person had a right to be heard. Now, that doesn't mean that I have unlimited patience in that respect. I have developed ways over the years that I've cut lawyers off, particularly by telling them that I think I understand their position. And that usually does the trick and stops them from arguing the point any further. I also think that a good trial judge must have humor. He or she must exhibit, particularly for the jurors, a sense of humor and a feeling that what's happening in this courtroom today is a normal aspect of our lives. It's not something that's all that unusual. And I always prided myself in my relationship with the jury. I don't know whether you detected any of that in the several trials that you witnessed or not, but I took great pains to try to build a rapport and exercise that rapport with the jurors. For example, one of the things that I noticed that somebody had said was greeting the jurors in the morning. Well, as you recall, on the second morning of my trials, the jurors were always very vocal, which is a result, I think, of the first morning of my trials. When I usually speak to the jurors, I say, "Good morning, ladies and gentlemen of the jury, how are you doing?"
And you do that from the bench?
Oh, yes.
Okay.
And typically receiving a muted response. I also typically then cut my hand behind my ear and say, "I'm sorry, members of the jury, I wasn't able to hear you." And at that time, they blast me off the bench by saying "good morning" in a very loud tone. So that's just one of the ways that I have always been able to communicate with the jurors. When I first went on the bench, I developed a questionnaire that I passed out to the jurors that had a lot of questions about the case, most important of which was, despite my admonition otherwise, whether they had any feeling that I was in favor of one side of the case or the other.
And Judge, did you do that after the case was over?
Yes.
Okay, not while they're deliberating, just afterwards.
after the
Okay.
case was completely over.
Okay.
I also told them that they were not required to respond to the questionnaire. If they wanted to discard it, they could put it in the first trash can they saw after they went out the door. But most jurors did respond, and I'm sure, I'm absolutely sure that they fibbed a little bit on some of those things, because no matter how difficult it is to show impartiality, I'm sure that comes bound to come through with the judge. But in any event, it was something that I carried and did regularly.
And did most of the jurors say they felt that you were impartial, that you didn't have a leaning to one side or the other?
I don't ever recall getting a contrary answer.
That's wonderful.
Another part of the job that I think is very important is for the trial judge to leave no doubt in the minds of those in the courtroom who is in control of the courtroom. I was on the bench for 42 years, as I've indicated, and I'm proud to say that I never used my gavel. I felt early on that if I was unable to maintain order in the courtroom without the use of my gavel, that it was probably time for me to quit the job or seek help in some other respect. I used to twirl it a lot, but I never used it. And I think I was always able to control the courtroom with my voice. And if the judges who hear this would like a comparison of this matter that I've just brought out, I invite them to watch a retrial or replay of the O.J. Simpson case, in which the judge, his name was Ito, I-T-O,
Right.
completely lost control of the case early on. I think the lawyers controlled the case, and I thought it was a terrible example of a judge presiding over a case. Another thing I think is important with the lawyers, for the being a good judge, is to always use your time with the jury in a prudent manner. I think the jurors need to feel comfortable, that they need to have their time, that know that when they're there, their time is being utilized, that the lawyers and the judge are not back in his chambers or her chambers telling jokes and drinking coffee, which happened a lot in my earlier career, but never, ever happened during the time that I was a judge. I told the lawyers in every trial that I expected them to be able to address the matters that they could outside the presence of the jury during recesses and before and after court. That while the jurors were present, I wanted them to be working, and I wanted them to know they were appreciated for their service and that we weren't going to waste their time in any way. I want to say that I always loved my job.
What did you love about it, Judge Brit?
Seeing good lawyers who were well prepared on the law and well versed in the facts, fighting in a good legal battle. And I think by virtue of my position, I was able to see that most of the time. The lawyers who appeared before me were so much better versed and well prepared than those who appeared in state courts with me when I was practicing law in the state court. And I have a graphic example of that. When I was trying a case early on of excessive force, the difference between the lawyers was palpable. The plaintiff's lawyer was a young man who obviously didn't know what he was doing. He was just trying to do the best he could with what he had, but he had a wonderful case. His client was shot in the back by a police officer from a city in eastern North Carolina. And when the case was tried, it was a defense verdict. I immediately set the verdict aside and ordered a new trial. When it was retried, and the lawyer for the defendant was one of my close friends. I'd known him for all his life, or all of our lives. The verdict was the same the second time, and I decided I really couldn't do anything any further than that. But it was a miscarriage of justice, and I regretted it a lot, but there was nothing else I could do. I remember also presiding over a criminal case in which the evidence presented by the prosecuting attorney on a charge of lying to a case agent, perjury, was so weak that I started to allow a motion to dismiss by the defendant at the end of the evidence. I decided not to, reasoning that the jury would see the matter the same as I had, and that would put a cap on it, and that would be the end of it for that poor fellow who had been brought in to be tried. Lo and behold, the jury found him guilty. As soon as the jurors walked out of the courtroom, I declared a mistrial because of the lack of evidence and ordered that he be retried. The government somehow appealed to the Fourth Circuit Court of Appeals, which in a 2-1 decision affirmed my decision. Regrettably, the Solicitor General of the United States decided the case was of such importance that they should petition for en banc review by the Fourth Circuit. They did. The Fourth Circuit, in a 6-5 vote, overturned my decision and said that the fellow should be tried, or he was guilty. When it came back for sentencing, the United States Attorney appeared to have a lot of feelings for the defendant and argued for a probationary sentence. When it came to sentencing, I looked down at the defendant and I said, "Mr. Defendant, your case has been heard now by 12 United States district judges. 6 of them believe that you have committed a crime, and 5 of them believe that you have not committed a crime. Unlucky for you, the 6 of the judges who have made that decision are appellate judges. On the other hand, fortunately for you, the judge who will pass sentence on you, that is me, believes that you have not committed a crime. And I'd like to ask you, sir, do you have a $1 bill in your pocket?" And he said, "Yes." And I said, "Well, if you will hand that to the clerk of court there, you can go out of here a free man. You don't have to worry about this thing anymore." And I told him, I noted for the record that the court sentenced the defendant to a fine in the amount of $1. The costs were waived, and the case was ended. I really felt good about that.
It's a great story.
Another thing I think that is important to being a good trial judge is being timely. I recall early on in my career when I was living in the small town of Lumberton, North Carolina, and driving back and forth to my duty station, which was in Fayetteville. My secretary and I at the time split the duty of driving each week, with one of us driving one week, the other week. And I caught myself speeding one morning, and I looked at her and I said, why am I doing this? I said, they can't start without me. And if they don't start without me, nothing can happen. As a result of that, I always started my court on time. But more importantly, I learned the lesson of how important it was that I be on time, because I couldn't ask other people to be on time unless I also was prompt. And I became probably fanatical about that over the years. The lawyers learned that, and also learned that they better not be late for Judge Brit's court. I've even started a case without the U.S. Attorney present, but I could not do it without the criminal defendant present for obvious reasons. One other thing I think is important for a trial judge is to show no favoritism toward any lawyer in particular or cause. I have two examples of that. One of which is, over the years, I became quite concerned about the lawyers and the parties and the witnesses in the courtroom who were chatting with each other and who would talk to, even though at a whisper, you could always see it. And I developed a reputation for calling the people down when they did that, and I was always trying to be nice to them. I'd tell them to go outside if they wanted to talk, and I'll come back in when the next session began or something. But one time I had to do that to a lawyer, and it was one of the preeminent members of the bar. I think that example of me doing that was illustrative of how important it is to not have any favorites when you're making decisions in the courtroom. Another example is, and this is more of a story, I think my good friend has heard it many times, he even believes it, but he's one of the best lawyers that I've ever known. On one occasion, when he was before me arguing a point, we were having a right good discussion back and forth, and I looked down at him and I said, Mr. Boyce, are you trying to show your disrespect for this court? And he looked up at me and said, no, Your Honor, I'm doing my very best to conceal it.
What was he doing that made you think he was being disrespectful?
Just to tell.
Oh.
I remember very well when I was trying a case before a judge in the Superior Court in Lumberton, my hometown, who had the reputation of being one of the strictest judges on the bench. And he and I were having a heated discussion about a point of law or something. I finally ran out of arguments, and I looked up at him and I said, no apologies, Your Honor. And he looked down at me and he said, none asked. So, that was remarkable. The hardest thing about being a judge is passing sentence. If that doesn't bother judges, then I don't know what does.
What advice would you give to the criminal judges that have to pass sentence? Do you have anything that you did or thought about it that made your job easier?
I remember back when the guidelines were adopted, and I thought how wonderful they were, because they sort of leveled the playing field. I had been at a judicial meeting before when we were presented with hypothetical situations in which the sentence of the judge varied tremendously. And I thought that added some stability to the system. But as time went on, and even though have the reputation of being a firm judge, I felt that the sentencing guidelines were too restrictive. And every time I've deviated from them, the government appealed and the Fourth Circuit reversed me. I remember my joy when the Supreme Court, in an opinion by Justice Breyer, held that the guidelines were advisory only. And from then on, it made sentencing a lot easier. I've also been glad to notice since I stepped down from the bench that the Sentencing Commission, anyway, it's the 18-to-1 ratio of crack cocaine to cocaine, powdered cocaine, which has been the rule in the federal courts for years, and which I've never followed because I felt it was outrageous. And there's a decision by a judge in South Dakota, which I've quoted often in my sentences, that pointed that out. And now the government has taken the official position that there is no difference, that all should be treated the same. I felt then, as I do now, that it was used unevenly toward poor and non-white defendants. One thing that is a pet peeve is tardiness,
Right.
which you could also imagine from things I've already said. Also, a lack of preparation. It is so evident when a lawyer comes before a judge in court ill prepared and not able to do his or her job because of lack of preparation or lack of familiarity with the subject facts of the case. And also, I guess it's a pet peeve, but the case that I told you about that where the was tried twice, and I set the verdict aside, which was ineptness on the part of an attorney. I probably didn't handle that the best. Thinking back on it, I let it go to trial twice, and it was the same result. And I figured it would be same would be the result if it was tried again. But I probably should have thought more about that. And one of the last questions you also asked me was advice to new judges. And the first piece of advice I would give to new judges is, if it is possible, to get a mentor. The second piece of advice I would give them is to decide promptly, whatever the matter is. If it's a ruling on a question of admissibility of evidence or a decision on the merits, decide the matter promptly, because, as I've indicated, as Frank Dupuy taught me, you have so many cases and so many decisions left to make. You don't need to be bothered thinking about the ones that you've already made. Another piece of advice I would give to new judges is to read all of the decisions that you can, particularly of the Circuit Court of Appeals that you're under. The Supreme Court decisions are important, and the results of those should be made available to you in a timely manner. But I had a rule that I tried to follow over the years in reading every decision in my circuit where the district judge was reversed.
Mm.
in every unpublished decision and every published decision, no matter what the result was. So the last advice I would give to judges, I'm sure all of the new judges on the bench have heroes. That is judges who they have tried cases before in the past, who did things the way they liked them. I had two such judges in my life, both of whom were state superior court judges, and I did my very best to emulate them, to do these things that they were able to do and act the way they acted. I think that necessarily implies that you pick out some things judges do that you do not like, and discarding that. Don't use that in any way in what you're doing. But the greatest advice I'd give to new judges is to enjoy your work and don't look back on it.
Well, that was wonderful, Judge Britt. I mean, I could just talk to you for hours. You have so much life experience. But I'm going to end with one question. It wasn't in the questions I wrote, but what would you like your legacy to be when you're gone, or when judges are talking about you? What is it that you've worked so hard for your legacy to be? What do you want people to say about you?
That he was fair and impartial.
Beautifully put.
If lawyers who appeared before me could say that would be all that I could ask for.
And I think they all do.
I remember very well when lawyers in the county courthouse where I lived on Monday morning would go into the judges' chambers, and everybody would sit around and drink coffee and tell war stories and things of that nature for long past the opening of court time. And the jurors were sitting out in the courtroom twiddling their thumbs and inactive and had nothing to do. And the second thing is, I remember very vividly standing in the hallway just outside the courtroom in the county courthouse where I lived, and looking out the window and seeing a juror running down the middle of the street trying to get back to court on time because the judge was so adamant about jurors being there when they were called on, even though the judge himself was not that prompt.
It's been a pleasure. Thank you so much, Judge. I really appreciate your time, and this has meant so much, I'm sure, to the judges that are going to watch this. Well, thank you. Have a wonderful day, and keep in good health, Judge Britt. We miss you on the bench.
Take care.
That concludes this episode of What Makes a Great Trial Judge, part of the Lawyer Minds ecosystem. We hope you'll take some of these trial tips and incorporate them in your everyday practice to improve the litigation process for everyone involved. Please consider subscribing to this podcast and take some time to explore the other content Lawyer Minds has to offer. Your feedback and ideas are always welcome. Thanks for listening, and see you next time.